Good morning, everyone. Good morning, everyone.
Morning.
Morning, Ron.
Good morning.
Morning, Ron.
Morning, Aaron.
Morning,
Morning,
Aaron.
Aaron.
Sir, could you please call
Morning,
the
Aaron.
case? Sir, could you
Good
please
morning.
call the case?
Good morning, Your Honor.
Action number three,
Action number three,
568 of 2020 FDA, Misenga Jones
FDA
versus
Jones
the
versus
Guyana Election Commission and
Guyana
others.
Election Commission and
Lady,
Good morning.
in this matter, Mr. John Jeremy, Senior Counsel, Mr. Roysdale Ford, Senior Counsel, leads me, Keith Scotland, and Mr. Ronald Keller, instructed by Mr. Mayor Robertson, on behalf of the applicant, Misenga Jones.
Thank you. Is anyone appearing for Guyana Elections Commission, the first respondent? Can we go to the second respondent, Chairman of the Guyana Elections Commission?
May it please, Your Honor, Kim Kite Thomas. I appear on behalf of the second named respondent, Chairman of the Guyana Elections Commission.
Third named respondent, Chief Elections Officer.
May it please Your Honor, Neil Boston. I appear on behalf of the third name respondent.
The Attorney General.
Honor Maxwell E. Edwards, Attorney General Walter Williams, Senior Counsel Person. I am in association with him.
Yes, and I have a number of applications for persons or parties to join. I think the first that we received was from Mr. Khan. Mr. Khan, you'd have to unmute. Mr. Khan?
Your Honor, is it Mr. Khan or Mr. Kissoon?
Yes, I'm seeing him. Or before we go to that, I go to Mr. Khan whilst we sort out his technical issues. I must mention, I thank all counsel and the party for coming on to the hearing at very, very short notice. Of course, this is a case of national interest and importance. And I want to say thank you to our IT team here at the Supreme Court, led by the Honorable Justice Kananan, and with some support out of from our colleague in Trinidad, for allowing us to live stream this hearing. It's our first live stream, I understand, of a hearing in Guyana. And I'm very pleased to announce that we have managed this overnight. I know our team has been preparing, not for this matter, but they had to work assiduously overnight into the wee hours of this morning to ensure that we have the live stream so that members of the public and the wider region and the world can hear this matter. So I want to thank my IT team for the hard work that they put in to get us here today. And to say to the public, as we have stated throughout this COVID period, we can still hear you. Yes, the can available. If not, we will move to Mr. Mendez. I have a second application by Mr. Ali and Mr. Jagdio to join.
Yes, I am leading Mr. Nandlal and Mr. Kissoon on behalf of the two applicants. Not too sure if there's any objection on the part of any of the named parties to this application.
Yes, I appreciate it. I'm going to deal with that shortly.
Much obliged.
Yes, is anyone in communication with Mr. Khan? I see Mr. Mohammed Khan and Mr. Kashir Khan on the hearing.
If it please, Your Honor, I just saw a note from Mr. Khan saying he has technical difficulties. He's trying to get back onto the system.
Yes, madam. He just indicated to me that he's experiencing some technical difficulties.
Very well.
Okay, may I please, Your Honor?
Yes, Mr. Khan.
Whilst
Mohammed Khan, that is.
Kashir is getting his technical difficulties sorted out, we're hoping to make an oral application to be joined to represent the Citizens Initiative and Change Guyana. Kashir is back, and I will cede to him.
Good morning, Your Honor.
Well, just a minute, Mr. Mohammed Khan, you are with Mr. Kashir Khan representing
the Citizens Initiative and Change Guyana.
Yes, Mr. Kashir Khan.
Good morning, Your Honor. My apologies because the internet seems to have been conspiring against me this morning. May it please the court, as indicated by Mr. Mohammed Khan, I act myself, Mr. Mohammed Khan, along with Mr. Kalesh Lokman, appear for the Citizenship Initiative and Change Guyana, two of the political parties that contested the March 2nd, 2020 general elections. And we crave the court's indulgence to be added as a party to these proceedings pursuant to section 13(1).
I'm not getting any sound. No sound.
Could the instructions would have been that all those who are not asked to mute their mics. Mr. Ramkaran?
No, I'm not getting any sound.
Mr. Ramkaran?
Poorly.
Mr. Ramkaran?
Your Honor, I'm having tremendous difficulties hearing the proceedings due to the heavy rainfall outside. I have an application for a new and united Guyana to be added as a respondent. We have been unable to file that application, upload it, but it is prepared. We seek Your Honor's leave to file and to file an application.
Okay, could you enter your appearance, please?
Pardon me, Your Honor?
Could you enter your appearance formally, please?
I am for a new and united Guyana, please, Your Honor.
Your name? Your name for the record, please. The Council for a New and United Guyana, could you give your name for the record, please?
Kamal Ramkaran, please, Your Honor.
Thank you. Is anyone associated with you?
For a new and united Guyana, no, please, Your Honor. But I understand that Mr. Harry Ramkaran, Senior Counsel, appears for Liberty and Justice Party. I'm not sure whether he's able to come on because I haven't been able to hear.
If it please Your Honor, Mr. Timothy Jonas, or the New Movement, represented by Josh Kanai.
I didn't get the name, Mr. Jonas, sorry. The New Movement, represented by?
Daniel Josh Kanai, please, Your Honor.
Kanai.
Thank you very much. An application was filed electronically this morning with the undertaking to pay the fees at soonest opportunity.
If it pleases Your Honor, Sanjeev Datadin with Mr. Stephen Singh and Jamila Ali for Dr. Vishnu Bandhu on behalf of the United Republican Party.
I have Ms. Jamila. Ali, could you give me the name of the other counsel, please?
Stephen Singh. Stephen Singh.
And this is for which party? Sorry?
For Dr. Vishnu Bandhu on behalf of the United Republican Party. An application was filed this morning and should have been electronically served on Mr. Robertson.
Very well. Anyone else? Okay, I think that covers everybody who would like to apply to join these proceedings. Mr.
If it pleases, Your Honor, my apologies, Your Honor. I was having some difficulty with my audio. I'm Haru Ramkaran, Your Honor, and I would like to enter appearance on behalf of Mr. Lennox Schumann of the Liberty and Justice Party.
Very well, thank you.
Our application will be filed during the course of today. Your Honor, I don't know if Mr. Kamal Ramkaran has entered appearances yet.
Yes, he has, for a new and united Guyana.
Thank you.
If it pleases you, madam, I'm not sure if I made it clear that my application is for Mark France, who represents New and United Guyana. Kamal Ramkaran.
Yes. Now, counsel, on behalf of the applicant, because I don't know which one of you would want to respond, is there any objection to the persons or parties who are seeking to join these proceedings? Is there any objection?
Your Honor, this is a matter within your discretion. John Jeremy here. There's no objection from the applicant. We just wonder whether the principles, as Your Honor would know, if applied properly, would allow for the addition of all of the parties to be joined. And I say that, Your Honor, because Your Honor has fixed this hearing, this case management conference, within 24 hours of us filing. Now, the principles on joinder, as I understand it, seek to balance the efficient use of the court's time and fairness to parties. And the test would be whether the joinder of a particular party adds anything to the matter. So I'm not sure, I have not seen the applications. I'm not sure what they add or what they might add. We seek no reliefs against any of these persons. This is a dispute in respect of the exercise of certain powers of GECOM. And while I can accept that perhaps one of the others might wish to be joined, if we have 10 parties seeking to be joined, the proceedings are likely to be drawn out. And Your Honor has to balance the interests of an efficient and expeditious use of the court's time with the interest of 10, 12 persons. I lost count in the same day of being joined.
Thank you, Mr. Jarman. The only difficulty I have with that is that I would not be able to decide which one to choose. So I think in the interest of justice and fairness, I would allow all the persons who this morning through their counsel, or the parties through their counsel, who are seeking to join to do so. I have of course read the application, and I do have some orders in relation to how we will manage this matter, so that we can expedite it. So while, Mr. Jeremy, I do appreciate what you have said in relation to efficiency and the need to have the matter dealt with expeditiously, I think what I have devised as a CMC order should address those concerns. So we will expect the hard copies of the applications by those who have filed them electronically to be in this morning. Well, just after the hearing, if you have not already sent it to the registry. Well, now for my considerations in relation to my directions in relation to how we will proceed. Having read the application, to my mind, the nub of the issue is whether Order 60, that is the, for want of a different terminology, the recount order issued by GECOM, whether that order was valid and is valid, such as to permit a declaration of the March 2nd, 2020 election results based on the recount pursuant to that Order 60. To my mind, all the 28 odd claims for relief are hinged on that issue. And therefore, I do note that the very first prayer for relief speaks to issues of jurisdiction. So I have itemized these as the issues that the court has to consider. Whether this court has jurisdiction to hear this application, the second point or issue I will raise, which is really tangential to the major point, but I include it here now because I think it precedes that issue, and it's mentioned in one of the reliefs sought. That is whether Section 22 of the, let me just find it. Yes, Section 22 of the Election Laws Amendment Act number 15 of 2000 is unconstitutional, whether it is constitutional or unconstitutional. And then the main one, which I just mentioned, whether Order 60 and by extension the recount results obtained therefrom are valid, such as to permit a declaration of the March 2nd, 2020 election results based on the said recount. Tangential to that, and importantly also, is whether the declarations of the returning officers pursuant to the Representation of People Act should be set aside or retained, and whether these issues are res judicata, given the decisions of the Court of Appeal in Moore and GECOM and others, Civil Appeal number 38 of 2020, and the Caribbean Court of Justice, and the decision of the Caribbean Court of Justice in Ali and Jack Dew and David and others, GY Civil Appeal number 41 of 2020. So that is how I have formulated the issues to be determined, and so that when those issues are addressed, then I can consider whether the 27 substantive orders claimed can be granted, and 28 with such further order as the court deems fit. So that is how I have worked it out. Now, in terms of how we will proceed, Since the applicant is clearly very, very prepared, given what I have read, their submissions are to be in by 11 o'clock tonight. All respondents, that is, all persons who were originally named and who have been added, are to file their submissions by 10 p.m. tomorrow night. That is 10 p.m. on Thursday, July the 16th. The applicant can file a reply if necessary by 11 o'clock of 11 a.m. on Friday, July the 17th. All the submissions are to be no more than 10 pages long, including footnotes and references, Times New Roman font 12 with 1.5 line spacing. I will hear oral arguments in this matter on Friday the 17th, starting at 2 o'clock in the afternoon. Now, with the numbers of persons who have joined, the applicant will have 30 minutes. There's been no appearance by the second respondent. Chairperson will have 20 minutes. I think a lot of the arguments I know have been canvassed more than once in other matters, so I'm anticipating that you're able to pull this together pretty quickly. Mr. Boston for the CEO, 20 minutes. And we have now six. We have 6 added parties. You will each have 15 minutes.
Your Honor, if I may be permitted, the Attorney General is not added. He is a party.
Yes, just a minute. I missed him. Sorry. Just a minute. Yes, AG will have 20 minutes. And then the applicant, I have missed it. The applicant will have a chance to respond. In 20 minutes. We will have some breaks in between the oral submissions. After the applicant and the chairperson, we just have a short break of about 5 to 10 minutes. After the CEO, and about 5 minutes. And then we'll take each of the added respondents and have a break, and then the applicant, and then we'll have a wrap. Okay, that should take us about around 5:30 on Friday afternoon, but we have to push it. And well, I'll give more directions in relation to a decision once I see the written submissions. I'm hoping that I can give this decision by Sunday, but it all depends on what is presented.
Milady, may I?
Your Honor, may I inquire whether there's any order for the respondents, the added parties, in terms of giving submissions?
No, everyone is to give their submissions by the same time. There's no order.
No, I'm talking about the oral submissions. Is there any order that Your Honor has put? Will hear the parties?
Well, Khan made his application first, then Mr. Jaggi and Mr. Ali, Mr. Kamal Ramkaran, Mr. Ramkaran Senior Counsel, Mr. Jonas, and then Mr. Dattadin. It will be in the order as counsel presented themselves this morning and their applications as filed.
Thank you very much.
Your Honor, if I may.
Yes, please, Mr. Mendez.
First of all, could you grant us the leave to rely on the affidavit?
Yes.
That we have filed in support of our application. And in addition, in very short order, to file a supplemental affidavit to include some further information that would be relevant to the issues as you have described them.
I should have mentioned that, Mr. Mendez. Thank you that having received the hard copy application on behalf of Mr. Ali and Mr. Jagdiu, that affidavit is pretty extensive and therefore it would be deemed, rather than you filing a new one, that affidavit, I did have that in my notes, that would deem an answer to the application. But to be honest, though, I must say, having read all that is there, I don't know that there's much more that needs to be added factually. This is really a legal issue.
Mostly it is, milady, but there may be certain factual issues that arise in the course of argument. So this is why I'm seeking your leave by this afternoon at 4 to file a supplemental affidavit to that, including certain pertinent information. It won't be a long affidavit, but there's some information that would be needed to supplement what is already there. May I have your leave to do that, please?
Can you do so before I would give the applicant an opportunity to respond?
By 3, milady?
That's going to put a little pressure on them. 11. Let's make it by 2 o'clock, which is the COVID time by the court.
By 2 o'clock then, milady.
Because they would have to, I'll give them an opportunity to respond, which they can do so along with filing their submissions by 11 tonight.
Thank you very much, ma'am. If I may raise one further issue, as you would appreciate, what the applicants are seeking to do is to have you make orders that the GECOM not declare the elections in relation to the recount. And of course, as we all know, the recount indicates that the lists that my clients represent won the election. So effectively what they are seeking to do by the orders that they ask you to make is to unseat my clients and those that they represent. So I'm saying, this is a run-up, my ladies. It's a run-up. I'm about to bowl the ball. And the ball is that in those circumstances, I'm asking for more time than the 15 minutes that you would have allocated to us, having regard to the fact that certainly of the respondents who are joining, that we have a keener interest in the outcome of these proceedings than even the Attorney General, I'd respectfully submit. So that we're asking for more time to present our case when our time comes.
Mr. Mendez, when you get to your 10, when I read your 10 pages, I will decide whether it is necessary for you to have more than the 15 minutes allotted. In any case, if I have questions, it may end up that counsel for all the parties may end up going over their time by a bit. But we're trying to keep this as condensed as possible. I think the issues are very, very clear. So there's absolutely no need to be roving all over the place, with all due respect. I think it's
I don't usually rove, Your Honor, but in any event, I understand your point.
For everyone, because, you know, sometimes it happens that you know, in the exchange between the court and counsel, the time could be extended. So let us try to keep as focused as possible, and I will read your submissions so that I would know whether I have any burning questions to ask, or whether you're just highlighting very specific points.
Your Honor, before you rise, may I respectfully inquire whether it is to be taken for granted that there is an order maintaining the status quo at GECOM? As regards the GECOM not proceeding to make any declarations in regard to the various issues that are before you in this application?
If it please Your Honor, I wonder if that request was just made by the applicant before you. I don't think the party
Mr. Jonas, I'm not complete. Mr. Jonas, I'm not finished.
Mr. Edwards, you are not in control of this court. So do
Well,
not do not get into an argument and cross talk with counsel. It's not permitted.
Well, I was not finished, Your Honor. With all due respect, I was not finished.
Well, I got the impression that you were finished.
No, very well, Your Honor. Your Honor, may I be permitted to complete?
Just a minute, please. I'm making.
Thank you.
Yes, Mr. Edwards, you're requesting a stay. Well, I don't know that status quo be maintained. Is that,
yes.
Am I understanding you correctly?
Yes, Your Honor.
And what is that status quo?
Your Honor, we were just adopting the approach or practice of the CCJ.
I know, but I'm trying to understand from you, what is the status quo that you would like maintained? I do not.
The chairman of GECOM does not proceed to make any declarations or decisions, declaration or decisions in relation to the various issues that are before Your Honor.
Thank you, Mr.
Thank you, Your Honor.
Very grateful, Your Honor. I was also under the impression that Mr. Edwards had finished. I apologize for having interrupted him if I did so. I believe that Mr. Edwards represents the fourth named respondent who has not made any application with a substantive or interlocutory before Your Honor. I am therefore somewhat taken by surprise that Mr. Edwards is verbally making an oral application for interlocutory orders as a fourth named respondent.
I join with Mr. Jonas in that observation. The Attorney General is a respondent to these proceedings. He's not the applicant. And I've said this a number of occasions that we expect the Attorney General to be neutral in these matters and not to take a side. Well, obviously, it's indicated immediately what side he's on. It is improper for the Attorney General to be seeking relief as a respondent when the applicant has not made any application whatsoever.
Please, Your Honor. As I understand our Constitution, Guyana's Constitution, our supreme law, the Attorney General is the custodian of the Constitution. And the Attorney General then applied to enter into this case. The Attorney General has been made a party to this matter, simply because if one were to have a proper apprehension of our Constitution and our rules of court, etc., that where matters of the Constitution is involved, where matters are involved in our Constitution, the Attorney General under our CPR 2016 is a proper party to be made a respondent. It's basically an elementary rule in our system.
Ms. Kai Thomas, do you have anything to say in this regard?
Your Honor, as has been my client's position in relation to these matters, once these matters are pending, I believe she has conducted herself throughout all these proceedings in a certain manner. And I believe, Your Honor, a similar approach will be taken in respect to this matter. So that I don't believe there should be any apprehension by any party here that any decision will be made which would somehow make the exercise of this court's jurisdiction, in some form of futility. My client has never conducted herself in that manner.
Thank you very much, Ms. Kine. Well, that addresses the issue, Mr. Edwards.
Thank you very much.
Good. So we will adjourn now to.
Your Honor, if I may, I'm sorry.
Yes, Mr. Khan.
Your Honor.
Khan, that is.
Yeah, Your Honor, there are two housekeeping matters which I would like to ask the court to address. And that is, just for the sake of completeness, having been joined in the matter, pursuant to Order 9-1 of our CPR, jurisdiction is being made an issue by the respondents who I represent. I understand and appreciate that Your Honor has made it one of the issues which we are going to address. But just for the sake of completeness, I would like to place it on record that pursuant to Rule 9-1, we are raising the issue of jurisdiction.
Well, that would be part of your submissions, Mr. Khan.
Yes, Your Honor, but like I said, I simply wanted to be made part of the record that we are invoking.
Mr. Khan, you would have an opportunity to make your oral argument, so it would have been a matter of the record anyhow.
Grateful and guided, Your Honor. Secondly, given that this particular application for judicial review falls under the purview of Part 56, I would be minded to inquire as to whether or not my friend for the applicant will be filing any additional documentation that is required pursuant to Article 56, 5, 1, and 2.
Part 56.
5605, 1, and 2.
Okay, could you be specific as to those rules?
Okay, this is what Part 56.5.1 says. Where a proceeding seeks an order or writ of certiorari for the court to review other proceedings for the purpose of quashing them, the validity of any order, warrant, commitment, conviction, or record may not be questioned unless A, a copy of the order, warrant, commitment, conviction, or record verified by affidavit is lodged with the registry before the hearing, or the applicant can account for the failure to do so to the satisfaction of the court. The decisions, as I understand it, that are being questioned are decisions of the Elections Commission. I'm just seeking some clarification from my friend for the purposes of my own submissions as to whether or not he will be complying with this order.
But I'm thinking that Part 1, Mr. Khan, speaks to certiorari, quashing a decision.
Well, it's or, Your Honor, seeks an order or a writ of certiorari to review proceedings.
Very well, Mr. Jeremy.
And I think that submission requires an interpretation of the rules, which I am not sure my little friend is properly put in before you. We have a copy of them. We will make sure that our application, in our view, complies with the rules. The time period between the filing of the application and the setting of the CMC has been relatively short. I will ask you, Your Honor, for sufficient time to speak to my instructing attorney in Guyana to make sure that all is well.
Very well, Mr. Jeremy.
And I thank him for his assistance. In respect, Your Honor, we were frozen out of, I'm not sure if Your Honor noticed that we were not with you for a while. The technology failed us.
Oh, sorry, I didn't notice. Sorry.
You were frozen out for a while during the AG's intervention. But we, as the applicants, were seeking an undertaking from the persons that, well, actually from the respondents to this action, that they do nothing to frustrate or to affect these proceedings which are afoot before your, that is in keeping with the principles of comity. And I would ask that they give an undertaking.
Mr. Jeremy, whilst you were unfortunately disconnected from us, Ms. Kite Thomas in effect gave such an undertaking on behalf of the second respondent.
Thank you. Thank you, Your Honor.
Well, thank you very much, everyone, and we will reconvene. For you, I think the advice would be about half an hour before, 50 minutes to half an hour before the time of hearing, so that we can try to iron out whatever technical difficulties. Again, we will be live streaming on Friday afternoon from 2 o'clock. When we will have, I will hear the oral submissions of counsel. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Good, Your Honor.
Great for your honor.
All right.